This is the second time we are bringing you. Listen to your learned friend, Saka, Richmond Numbo Saka, talking about the illegality of the election. Now, Solomon, give us some education. This business of injunction, because in the last few weeks it's been there. The hashtag Occupy Jolobi House thing. They also had injunction issues. And okay, please explain to us this process of injunction and all of these things that surround it. So, 1, what is an injunction? 2, how do I get one? And 3, if I go to court and I go and file and say, please give me an injunction, does it stop the other person from proceeding? Or once I don't have a full-blown injunction, the other person can go on and do whatever it is they want to do until the court gives a definite ruling on the matter?
So an injunction essentially is what we call an equitable remedy. It's something the court gives by way of discretion. The court looks at a number of circumstances, a number of factors, and decides to grant that injunction.
Okay.
So an injunction could be an order to restrain you from doing something, or even in some cases, to make you do something.
Okay.
So, for example, if I have a matter with you, I may have to first of all file an originating motion, or an originating, process. So, for example, a writ. And then after filing the writ, or together with the writ, I've also filed what we call the motion for interlocutory injunction, or the motion for injunction. The motion for injunction cannot stand on its own. It must stand on the substantive, writ. You understand? So the writ actually will determine what reliefs you are seeking from the court. So that is the substantive action you are going to the court with. I don't really know the facts of this GFA matters, but I'm just dealing with the general principles. So what happens is injunctions can be in 2 forms. There's an interlocutory and there's an interim.
Okay.
So, for example, you can go to court and tell the court that, okay, this is happening. Maybe you have noticed that tomorrow, or you've heard that tomorrow, some people are coming to demolish your house, and they will come. If nothing is done about that, they will come. And you have come because you have come to the court ex parte. You can come ex parte or you can come on notice.
Okay.
Ex parte means you are coming without the other person.
Okay.
So because it is so crucial that it must, the injunction must be granted, else what will happen cannot be remedied or repaired. Once you make the case to the court will grant you that, interim, injunction, which is often given ex parte.
Okay.
So the other one, which is on notice, is that you will have to serve the other person. You serve him. You put him on notice so that he will also come with his counter argument. If he has reasons why he thinks the injunction should not apply to him or should not be placed on him, he puts those reasons together, and the court will have to look at the 2 arguments based on its merit, or maybe based on the court's own discretion of what it thinks the issues are. The court will grant or dismiss the injunction application. So it could be on notice or it could be ex parte.
Okay.
Ex parte
on notice means
it's so
the
crucial.
other person is there.
It's so
ex parte means the other person is
there. But the trick there is that the ex parte often is given not more than 10 days, because you can't give ex parte injunction forever. It will not be fair to the other person, because maybe the facts as presented to the court may not be the totality of everything. So the court cannot just grant a blanket injunction. It will give you 10 days, and they will tell you it will expire in 10 days unless you come on notice. Then the court hears the 2 of you. Right, so that's fine. So the other question is, so you file a writ, you file an injunction, or maybe you've not even filed an injunction, you are just in a matter. Something happens and you think that no, you must come with an injunction application. When you come with an injunction application or a motion, once you serve the other person, the dominant view now is that that application serves as a stay on the other person. So if you are doing something and you are served, it means that you should stop until the matter is determined or the application is determined.
Now, how do I serve the other party?
So when I'm in court with you, I have to, when I go to court, I go and give the court the document. If it's just a matter between you and I, normally we file 3 of the same documents. One for myself, one for the court, and the other for you.
Okay.
So once yours gets to you, then you've been served. The court can get its own, but if you don't have yours, the court cannot go ahead and determine it because you don't know about it technically. That's why people try to swerve bailiffs, etc., because they don't want to be served. Once you are served, then it means you know about it and you've been given notice.
Okay, so the service from what you're saying is when I receive
When
my
you
copy.
receive your copy.
Now, is the service done in any special way? Do I need to see you and call your name and say, hey?
No, so there are process servers or there are bailiffs. There are people who work with the court who serve the processes. Or these are all court processes who serve the processes. So the bailiff will come to you and give it to you. So once he gives it to you, you've been served. So he enters, some documents in the court, proof of service, etc. Then he goes to place it on the docket or on the judge's file that indeed you have been served. It's important because any action the judge must take, the judge must be sure whether you know about this or not. So the proof of service on the file shows that indeed you have been served.
Okay.
So there are instances where people will say they won't take it. If they won't take it, the law allows them to leave it by you and go away. Once they are sure you are the one, they'll leave it close to you.
They can leave it close to you.
So you see some bailiffs throwing it at people and going away. Once that happens, if you refuse to take it, they can do that.
Don't mention names. Don't mention names.
Why
Reminds me of a certain Ghana football official who received an injunction at the Accra Sports Stadium. Now, when he was handed the document, he didn't know what it was until he opened it. When he opened it and saw that it was an injunction, he threw it away.
It's already.
Anyway,
so the service just means that you have notice.
Okay.
You have notice. So you can't say you didn't know about it. So if you have notice and you do not appear, the court can go ahead without you.
Okay.
If the court goes ahead without you, you can't say that you are not given a hearing. It is a very important. It's a very important part of the whole thing because of what we call natural justice. There are two main, principles of natural justice. The first one is that you must be given a hearing. The audio uttering pattern. You must be given a hearing.
Salam, just hold on. Just hold on. We have a bit of a technical challenge. All right, still listening to Sports Panorama. We're trying to get Selom. Yeah, I think Selom, we can hear you now. Apologies to our listeners. There was a bit of a technical hitch. Yeah, Selom, please proceed.
Yes. So I wonder where I should continue from. But so once you are served, yes. Once you are served, it means that you have notice of it, and once you have notice of it, the court can proceed without you. What is also important is that there are timelines given. So, for example, if it's a motion, you have 3 clear days. So you should be served, not less than. All right, let me. Okay, I think we are better now. Yes. Yeah. So you should be served. I mean, there are time limits. If it's a writ, you are given 8 days within which to enter appearance. If it's a motion, you have 3 clear days, to respond and all of that. So once you've not been short served means you were served, but you were not given the required number of days or the time necessary for you to respond.
Okay.
So that means you've been short served. Once you've not been short served and you've been served properly, and the day of the court you don't appear, the court can go ahead without you.
Okay. So now
you have service.
Great. So
now the injunction application, once you've been served, you are supposed to stop doing what the person is seeking to injunct.
Okay.
Okay. Before that, there were 2 views actually, that you could still go ahead and do it until the court determines the matter. But the courts have been clear these days that once you've been served, you have to halt all processes until that application is determined. And the court made. And
from what you're saying, it looks like the most important element in this is once the other party has been served.
Service is very important.
So once the service has been done duly, it means that the other party cannot proceed.
So this is what the court said in the Supreme Court case of the Republic versus Bank of Ghana and 5 others, ex-party Benjamin Dufour. It's a 2018 case also. It says, true as their contention may be, we believe that the respondents miss a very important aspect of contempt of court. They fail to consider the fact that contempt of court may arise where a party knowing that a case is sub judice engages in an act or omission that tends to prejudice or interfere with a fair trial of the case, despite the absence of an order of the court. So once you know that an action of yours may be sub judice, despite an order of the court, that could be contemptuous.
I see.
The court further said that when a court is seized with jurisdiction to hear a matter, nothing should be done to usurp the judicial power that has been vested in the court by the Constitution of Ghana. In effect, the state of affairs before the court was seized with the matter must be preserved until the court delivers its judgment. This is so whether or not the court has granted an order to preserve the status quo or not. So once you have been served, you know about it. Sub judice means under judicial consideration. Okay. So if I've come to the court that, okay, we are in the matter, but stop Nathan Kwa from building. Once Nathan Kwa is being served, and
he cannot proceed.
He shouldn't proceed. He shouldn't be building until the court determines the application, because that part of it is under judicial consideration.
That's right.
Sub judice is under judicial consideration. So if you go ahead to do that, what the court is saying here is that this is whether or not the court has granted an order to preserve the status quo or not. The granting of the order will come on the day of determination of the application.
That's right.
If the application has not been determined, it means that the order has not been given. But you are still caught with this because you know about it. And so why does the court do that? The court does so because if you go ahead to do what I'm seeking to injunct you from doing, then what's the point? Once you've done it, you know, the damage may not be remediable. I cannot remedy the damage you have caused. So for purposes of justice and fairness, let's all stop so that the court will determine the matter. So, for example, you have a goat and you want to kill it, and I've noticed somebody used to want to kill it. I go to court, that, okay, stop Nathan from killing the goat. I served you the thing, you go ahead and kill the goat. So now the court determines that, okay, Nathan shouldn't kill the goat. You kill the goat already. We can't bring it back to life. You understand? So that means that the judgment or the ruling the court would have given would have been rendered nugatory or obtuse. It would have been rendered useless. And the court should not give orders which are useless. And so it cannot be. So the court has the power to hold you in contempt because of matters like that.
Wow.
Now in practice, the recent matter of the EC and the NDC.
Yes.
The NDC was going for a congress, the Dufour Congress. The NDC was going for a congress. Dufour and co filed, some processes and filed an injunction application as well to injunct the process. Now this is so when the process was filed, they served the EC too, because the EC had a role to play in that election.
Yeah.
So they served the EC. This is what the EC chairperson told the NDC in a letter. Said, further to our meeting this afternoon on the above mentioned subject, we write to formally inform you that having been served with an application for interlocutory injunction, having been served with an application, not an order, an application for interlocutory injunction seeking to restrain the EC from supervising the conduct of the presidential and parliamentary primaries of the NDC, the commission will not be able to supervise the conduct of the said election slated for Saturday, May 13, until the determination of the matter. If they had gone ahead to do it, they would have been in contempt. So now, is it automatic? It may not be automatic. Somebody must bring the court's attention to the fact that this guy has done something contemptuous of the court.
I see.
The court will sit now and look at the factors and then see whether it is contemptuous or not. Even a recent case of the GFA and the Ash Gold about starting the league, not starting the league.
Yes.
The GFA, some of the officials were found in contempt because
the general secretary and chief of it.
Journalists were found in contempt because they went ahead and started the league when there was an application before the court about the same matter.
And they knew.
And they knew. They were served, so they knew. They were served, so they knew. There were about 13 of them. But the court determined that not all of them were served. But the general secretary and the general secretary was served. And he is the chief executive of the party, of the GFA. So, he controls stuff. And he knew about it. Yet he went ahead to start the league. So because of that, he was found in contempt. So that's what. So bringing this on, the question then is, the GFA election, should it have happened or not? I don't know. A lot will depend on George Friye and King Faisal and co. If they are minded to let it go, that's their own problem. But if they want to test the law, I think they should test the law and we see where it is. But it's quite clear what the law says.
Great.